This podcast is supported by FX's English teacher. Last year's critically acclaimed series returns to follow Evan, Gwen, and Marky as they vie for their students' divided attention. See why Cosmopolitan called its premiere season a masterclass of comedy, while Glamour raved it's the year's funniest and most heartwarming new comedy series. FX's English teacher. All new Thursdays on FX. All episodes now streaming on Hulu.
How do you top your love for your cat? With a cascade of decadent savory gravy over a mouth-watering mousse pâté. Fancy Feast gems. 2 gourmet pâtés in one convenient pack. Simply peel and plate to reveal a pyramid shape that makes eating delightful and pamper her with an experience as extraordinary as she is. Turn the everyday into the extraordinary with Fancy Feast gems.
How old are you?
I'm 30.
30-something. Okay, when you're 30-something years old, you need to clean up after your own act. And you're asking your auntie and your daddy to pull you out of trouble because you don't even bother to go see whether you can spend your retirement money without a condition before you spend it.
This is the plaintiff, Priscilla Jackson Baldwin. She says the defendant, her niece, called her crying because she desperately needed money to buy a car. She told her she'd already put down $3,000, and if she didn't come up with another $2,000, they were going to keep her money. She helped her niece out, loaned her $1,000. Now they don't even speak anymore. She's suing for the $1,000 she loaned her ungrateful niece, and can't wait for all this drama to be done with once and for all. This is the defendant, Makisha Jackson. She says her aunt, the plaintiff, gave her the money as a gift and told her she didn't have to pay her back. A few weeks later, she called and told her she was sorry, but she needed the money back. She was taken by surprise because the plaintiff gave her the money as a gift and is now trying to turn it into a loan. She's accused of annoying an aunt.
All parties, please raise your right hands.
What you are about to witness is real. The participants are not actors. They are actual litigants with a case pending in civil court. Both parties have agreed to drop their claims and have their cases settled here before Judge Marilyn Millian in our forum, the People's Court.
Be seated, come to order, please. Litigants have been sworn, Your Honor.
Thank you, Douglas.
You're welcome.
Priscilla Jackson Baldwin?
Yes.
You are suing your niece, Makisha Jackson?
Yes.
For $1,000 that you loaned her for a car that you say she has refused to repay. Tell me
Yes.
what's going on.
Well, as you said, this is my niece, Makisha. She originally called my mom one morning, about 6 in the morning. My mother called me and said, you need to talk to Keisha. Something's going on because she was crying so much. So I called Keisha. Keisha, what's going on? She's like, I purchased a car this weekend. I put $3,000 down, and I need $2,000 by Friday because if I don't get the $2,000, they're going to take the car back. She had post-dated a check. I said, Keisha, I don't have it. I really don't have it.
What was your plan? Why were you purchasing a car when you didn't have the other $2,000?
I had the $2,000 in my savings, but I was not able to get it from my savings.
Why not?
Because there are some restrictions. It was my Roth account, and so I had restrictions and I couldn't take it out.
And you didn't realize that when you bought the car?
No, I did not.
Okay.
So anyway, she cried, and I told her, I said, well, let me see what I can do. So I called my brother, and we talked about it.
Your brother is her what?
Father.
Okay.
Her father, and I said, look, she really needs the money. I said, I don't have it. I said, but I think I can get it, so let's try to put the money together and get it for her, and she's going to pay us back. When we got the money, I transferred it to her account, $1,000 to her account. Then my brother gave her $1,000. He didn't give it to her. He loaned her $1,000 as well, and that was put in her account. Before she got the money, I told her, I said, Keisha, I need my money back, and your dad needs his money back. No problem. If I have to give you my whole check, that's what I'll do. I said, okay. So after she gets the money, she takes care of her car, I guess. Then she had to move. So then that's going to be another extension. I said, okay, once you move, give me my money back. She moved, no Keisha. So I started emailing her. I said, every time I email her, how you doing? Do you have the money? And I have all my emails here. She's like, well, I don't have it right now, but I'm putting the money aside so I can give it all to you at one time.
Let me see the emails.
These are all the emails.
Thank you, sir. You're welcome. So go on.
So then it came the end of June, I believe it was, and she emails me and says, well, I emailed her first, and then she emails me back and said, I can give it to you on June 28th, July 5th, or July 19th. I said, you need to pick one date. So she said the 19th was a definite date she'd have the money in her account.
Right.
I said, okay, fine. On the 15th, I emailed Keisha. I said, hey, the 19th is coming up. You gonna have my money? No problem. My money will be in the bank so you can get it. Okay. Then on the morning of the 19th, I email, I say, Keisha, today is the day. Oh, my plans didn't work out, so I'm not gonna be able to pay you. So I said, really? So I said, at this point, it's time to go to another level. And that's when I filed my case.
What's your answer to all this?
Okay, first of all, the story that she told is not completely true. I called my father, actually, the day that I needed the money, and he told me that he didn't say he didn't have it. He said, call the moms, which is his mother, my grandmother. He said, call the moms, and they'll figure it out. And at that point, I was crying more out of stress because I reached out to my dad, which I normally do not. So I called my grandmother. My grandmother told me to call Scylla because I guess she takes care of all of her financial things. So I called Scylla. I told her what happened. I said I was asking my dad. I asked my dad for the money. I didn't ask her.
Okay, but
I
when
asked
she
my dad
offered
for
to
the money,
help out,
and
you
she
took her offer.
And she
so
said,
why aren't you paying her?
No, because she said, because when I was asking her, when I was telling her that I was asking my dad, and he basically was saying no, she said, well, don't worry about it. I'll see what I can do. And I said, oh, well, thank you. And she said, I'll be able to give you at least $1,000. And I said, well, I'll pay you back if I need to. And she said, no, don't worry about it. I'm just happy that I'm able to do it for you.
Did you ever tell her that she didn't have to pay you back?
No, I never told her that.
Welcome back to the People's Court. Harvey Levin here. Would you ever sue a relative?
No, I would not, because they're family.
They're family, but if they disrespect you by, I don't know, stiffing you, would you sue them?
Probably, yeah. If you had to. If it was enough money, I would.
How much is enough?
I don't know, say...
$1,000?
Probably, yeah.
$100?
Yeah, still.
$50?
Yeah.
Wow. What do you think?
I wouldn't. They're family. You should work it out among...
Yeah, but if they don't respect you and they say, well, I may owe you the money, but I'm not going to pay you, come on.
I wouldn't. It's just my opinion. I wouldn't.
Okay, fair enough. Going inside the courtroom.
Okay, what proof do you have that this is not
was
alone?
over the phone, so I don't have the call recorded or anything.
Who should I believe? You or my lying eyes when I read your emails saying
I know the email.
do appreciate what you and Dad have done for me. Mm-hmm. I will do my very best to give you all the money you loaned me.
And the reason why is because she initially wrote me this letter, and I didn't realize it. I should have corrected her right then and there.
Oh, you think? But maybe you didn't because you made a mistake and didn't correct it. Maybe you didn't because it was always a loan and you're a liar.
No, it was not a loan.
An ungrateful liar.
It was not a loan. And
I did have money set aside to pay you, but like I had said, I had a situation and I thought this extra money due to me would help me by paying you and Charles. Who's Charles?
That's my brother.
Okay, I am doing everything possible to pay you both back. I feel like if I would have just turned my back and not even struggled to pay you guys back, then that would have been fine. Really. But because I'm doing everything to come up with my debt, it's like I'm the bad one or irresponsible one. It's like I can't make any mistakes because if I do, I'm a disgrace. I hate that I am always the one to be singled out. Oh, you're the victim. I will do what I need to do to get you and Charles your money. God, sure sounds like a loan.
It was not, because she called me. She had called me a couple of weeks after she gave me the money. She said, I know I said that I didn't.
No, why would you keep calling it a loan? Then why don't you
because
stop?
then she said,
why don't you say, listen, this was a gift. You know it was a gift. You want me to pay it back now, I guess I'll pay it back. But you never, there were no strings attached.
I didn't want
How come
any
you don't
issues.
say that? Well, one reason you might not say that, maybe that it's not true and that you're full of garbage. Okay. And the part that bothers me is that when you are in, how old are you?
I'm 30-something.
Okay, when you're 30-something years old, you need to clean up after your own act. And you're asking your auntie and your daddy to pull you out of trouble because you don't even bother to go see whether you can spend your retirement money without a condition before you spend it, which is absurd. That's teenage stuff, not 30-something-year-old stuff. But instead of being mortified, okay, and grateful, you're actually, I know, lying in court against her. You're actually lying because I see every email you sent where you have nonstop talked about how grateful you are for, if you stare her down one more second, we're gonna have a problem. Nonstop talked about how grateful you are for the loan, that you wish you hadn't borrowed it, that you wanna pay your debt, and sometimes, my friend, when it walks like a duck, quacks like a duck, it's a duck.
I'm not
It's
lying.
not something else.
I am
Has
not
she
lying.
paid any of this money back to you?
No. And
do you know if she's paid any of it back to your brother?
Here's a notarized letter from my brother as well. She hasn't paid him back.
She hasn't paid anybody back. No. Well, you can only sue for yours, which is what you're doing for it, and I find in your favor. $1,000 verdict for the plaintiff.
Thank you.
Do you have your own children?
Yes.
Yeah.
What's your reaction to this verdict in this case here?
She's just a liar, and
The plaintiff you're talking about?
yes,
Yeah.
and I'm just very.
Why would she do that to you?
Because she's just being vindictive because of her situation, but it's over and done with. So.
Are you aware? Aren't you aware that it comes off looking like you're ungrateful? Though you don't want to look like that, right?
No, I don't. I don't have anything else to say. Thank you.
Thank you. All right, so you step out here and tell me what's going through your mind after this.
I'm happy that this is over with, and the judge saw that she was lying, and I had all my emails, everything to prove that it was a loan.
What effect has all this had on the family? You, her father, your brother?
Well, my brother, he's going to have to take a loss, I guess. But with me, at least I'll get my money, and that'll let her know that she needs to pay back her debts.
Mm-hmm. Your brother, her father, is willing to take a loss, as far as you know?
He's going to take a loss because she's not going to pay him.
Okay. All right. Over to Harvey then.
You know, for it to be a gift, it has to be very clear that it's a gift. Otherwise, it's a loan. And in this case, it was clearly a loan. That will do it for this case. Litigants for the next case on the way into the courtroom right now.
Dripping in gold? That's cool. Dripping in Velveeta's supremely creamy golden cheesiness? That's respect. Elevate your drip with Velveeta's range of outrageously delicious dips and dishes. Shells, cheese, melty blocks, and heat and eat queso that go all in on indulgence. Flex on your fam with a creamy, cheesy masterpiece and go all in on what you love with Velveeta. Respect the drip and satisfy your cravings. Bring home the drip with Velveeta.
This episode is brought to you by Indeed. When your computer breaks, you don't wait for it to magically start working again. You fix the problem. So why wait to hire the people your company desperately needs? Use Indeed's sponsored jobs to hire top talent fast. And even better, you only pay for results. There's no need to wait. Speed up your hiring with a $75 sponsored job credit at Indeed.com/podcast. Terms and conditions apply.
This is the plaintiff, Ernie Farley. He says he's been in the landscaping business for 25 years and was hired by the defendant to prepare his yard for an above-ground pool. He did all the work according to plan and still hasn't been paid for his services, which were rendered 5 months ago. So he's suing for the $531.75 he's owed. This is the defendant, Vincent Testanero. He says he built the pool on the land the plaintiff prepared, and when he filled it with water, it was obvious the land wasn't level like it should have been. The water kept spilling out of the low side, which was off by about 2 inches. He doesn't owe the hack a cent. He did a terrible job, and now he has a huge water bill to boot. He is accused of paying poorly for a pool.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case in the docket. The plaintiff is a landscaper who prepared the defendant's backyard for a pool, but says he got stiffed. The defendant says the land wasn't level. It's the case of level with me, bro.
Thank you, Douglas. Ernie's Lawn Service and Landscaping.
Correct.
You're the owner, Ernie Farley?
Yes, I am.
You are suing Vincent Testanero for $531.75 that you say he owes you that's still outstanding for some work that you did in his yard in order to prepare for his above-ground pool.
Correct.
He has paid you, according to you, nothing, correct?
Nothing.
Tell me what you contracted with him to do.
My contract with him to do was to dig out for a pool to level it. It was unlevel, to dig out one end and make it level, and then take the sand that he had in the yard and put it in and tamp that out. but the sand was wet, and we couldn't tamp it properly because it was mud. So if it dried out another week or so, then we can re-break it and tamp it. So meantime,
So why didn't you just wait if it was wet? Why did you do the job? I guess, I mean, if you came to it and you saw it was wet, why didn't you just wait then to do the job?
Well, I already dug it out. That was tamped. I got the sand off the driveway. I figured if I put it there,
It could dry in the spot.
it can dry out faster than being in a pile of sand.
Well, but aren't you putting it underground?
On top of the ground. Not underground, on top of the ground.
On top of the ground, and then you're supposed to do what with it?
Rake it out.
Right.
To grade, and then we tamp it. So it makes the sand.
How do you tamp it?
With a tamper. It's a
What's a tamper?
Gas-powered tamper.
What's a tamper? It compacts it down?
Correct.
Okay. And did you tamp it down?
We tried to, but it
I mean, how's it gonna, I'm just wondering how it's gonna dry out, tamp down. I mean, it didn't work out very well. The tamping of wet sand did not work out very well. All right. So according to you, you tell him what?
I told him that he would have to wait until it dries out, and we'll come back and re-rake it and re-tamp it.
And you told him not to put the pool up?
Right.
You told him that?
I wouldn't put the pool up.
You told them both that. And how did you tell them that? Verbally? Did you leave a message on the recorder? Did you send him a text? Did you send him an email? How did you tell them that?
It was on his voicemail.
Okay.
I told him that the ground is not level.
And how did you tell her?
I told she called me and told me they put the pool up, and it was.
Oh, that's after the fact. But before the fact, it was just him.
Just him.
Okay.
Yes.
All right. So then you get a phone call from her after they put the pool up, which is how long afterwards?
A week and a half.
Okay. And when she calls you, she tells you what?
That the pool is not level.
And you tell her?
That why did you put the pool up? It wasn't graded properly. We had to come back to regrade it.
Okay. And what did she say?
It looked graded to her. She said it looked fine to her. That's.
What happened? According to him, he told you don't put the pool up, you're going to have a problem, and then you had a problem, and then you didn't pay him. It's not his fault. That's what he says.
Yeah. That was not discussed at all about a time frame of wet sand or anything like that. That's just him saying that, actually, just to respond to that. It took us like 2 weeks to put the pool up from the time that
Had he said anything about don't put the pool up yet?
Not at all.
Not at all. But the day he left, you thought his job was done?
Correct.
Okay.
Yeah.
He didn't leave a message on your recorder telling you? No. Okay. So go on.
Okay. Well, what he was originally employed for was to obviously dig the area to level the surface for the pool that we were going to put up ourselves. He was to do that. He was to dig a trench to the garage where we already had the GFI outlets in the garage where we could run the line for a pump up by the pool, and to get rid of the original cost was going to be $400. He asked for an additional $100 to surface it. He was just going to dig and put the sand up in the pool area and leave it up to us to surface it.
So what's surface? Tamp?
Yeah.
Okay.
Yeah. And my response was that the reason that I figured that would be part of the deal, since you have a website showing that you do this for your company to do that for pools. And he said, well, that would be an additional $100 to tamp it, to surface it. And I said, okay, then I've got a lot of brush in the back corner of my yard that we cleaned out the whole yard. And sir, can you do that too?
What brush did you have in the backyard?
I had a lot of branches and so on from overhanging trees that we cleared and everything for.
But hadn't removed.
Right, and he was going to do that. And
is that accurate that you were going to do that as part of the deal?
No, there was only branches in the back of the garage that we were going to take away.
Do you guys have a written contract?
I don't have it with me. Do you have it?
Was there a written contract?
No written.
Then I'm mistaken. There was not then.
Was there one? No. According to you, no. And according to you now, no. Why? You helped him out and reminded him of the facts. Who are you? Come on up.
Hi.
Hi.
I'm his living girlfriend.
How long have you been together?
We've been together 2 years.
Yeah.
2 years?
Yes. And there was no written. Yeah, I
know. So the work gets done. The pool goes up. You don't realize that it's not tamped properly.
Not at the beginning. See,
when you say not at the beginning, when do you realize it?
When we were filling it with water.
Right.
Yeah.
All right. And according to you, he never told you we're not done.
No.
All right. And you didn't put up the pool until how many weeks later?
Like 2 weeks.
Wow. Okay, and after you fill it up with water, what do you see?
Certainly it wasn't level, and we were concerned right off the bat that if the water was going to make it over the pump, where the water circulates in on that end of the pool, was the water level even going to get that high? Because it was already very low on the higher end of ground and off level, where at that point in time it was a good 6 inches, and ultimately it settled into like a foot to a foot and a half imbalance on both sides of the
pictures?
pool. Yeah.
May I see them?
Okay, so this is.
Okay, hold on. Okay, this is how much tile I see here, and this is how much tile I see here. That's the reflection, right?
Yeah.
Right.
And that's not even to the end yet either.
Wow.
Yeah. Do you want me to keep going? It gets worse. So this is the water leaking
This is
out
when
on the side.
after it's sunk.
And what's happening there on the bottom is the sand is being washed away.
You see, Your Honor,
couple of
the
them.
bottom line is that Ernie even apologized to us that his men stopped digging on the higher end because they started to hit some roots. So what they did was they built up sand on the other side, and it all looked level at the beginning by, from the naked eye, until we started putting the water in, and then it was completely off balance, and then started spilling over the other side.
Did you tell him that? Did your guys end up coming across roots?
No,
You never told him that?
no.
And we sent him a letter that I have concerning that.
In the letter, do you say to him, you said blah, blah, blah?
Yes, miss.
And it's not miss, it's judge.
Yes, Your Honor.
I would also accept your highness. Did you respond to his letter? Let me see your letter to him. All right, now this is at the end of the summer. He does the work in June. This is at the end of the summer. We are in receipt of your invoice for work done at our home in June. However, after further research and much discussion, Deborah and I have decided we simply cannot afford to drain the pool and put it back up before winter settles in. What had you discussed with him doing that?
Yeah.
That you would take down, how much does it cost to take down the pool and?
It was over $600, yeah.
A whole day's work.
It was a day's work, and it was going to be
Do you have a
over
quote from somebody
$600.
for what that cost?
Well, no, it was the cost of the water to fill it, the salt that we used in it, and then we were going to have to obviously get more sand because the sand was now ruined.
Right. Do you have a quote for what it would cost?
No, we were actually going to do it ourselves. Ernie had lent us a pump to drain the water out, and then we decided that we couldn't afford to spend the money to fill the pool up again, add more sand and the salt to be able to use the pool. So we decided to try to let it go through the summer, let the kids enjoy it during the summer, and take it down in September. That's what we spoke to Ernie about doing. And then we just realized that it was just going to cost too much money.
Previously, we spoke about having your company come back out at the end of September to redo the poorly inadequate and unfinished job your company did on June 17th. But as I mentioned above, after figuring out the additional costs that we will have to endure, we cannot afford the expense. We do not feel confident. Furthermore, we do not feel confident in your services. You yourself stated to both myself and Deborah that your company did a bad job. Not only did you not complete the job for which you had been hired, and by this I refer to the clearing out of the debris in the far left corner of the backyard, but you did not properly dig out the base for the pool, and therefore one side is sunk to a difference of a foot. The cost to fill the pool, the sand that is no longer usable, the salt added to the pool is more than the $600 we're now out. At this time, we feel we owe you nothing, as services were not rendered. If you feel that we have erred, we welcome your response. Did you ever respond to the letter?
No.
Okay, the $500 and something that you are suing for, that you feel they should pay you, would be for what?
For doing the trench for the electrical conduit, but let me respond to that. Before I do any digging in somebody's yard, I have to do a call before you dig, and I have to mark out the areas that I'm going to be working. And I marked out where the conduit was going to go from the house.
But he says he had wanted you to mark out an area from the pool to the garage, not the pool to the house.
Right, but I marked out
Why don't I just look at the contract and see what there's no contract, so I can't really see what it says.
But I marked out from the house to the pool.
The house or the pool. The pool to the house, house to the pool. Right, but he had says that what he told you was to do it to the garage.
Yeah, that's not what I'm told.
See where a contract will come in handy?
Yeah.
Are you folks like picking up what I'm putting down?
Yep.
Like you say tomato, you say tomato. No, because that's the same thing. That's a bad example. You know, you say one thing and he says something completely different. I don't know. I wasn't there. I don't know what you people agreed on.
Help me out here. Psychologically, why don't people make contracts? Why don't they write stuff down? What's in their heads that makes them not do it?
I guess sometimes they might just not know that they need a contract. If it's for something simple, not business related, something like that.
Yeah, but if it's for something expensive, you know, they still don't do it. I mean, I'm trying to figure, why don't they make contracts?
Maybe they think that they can make out better in a deal if they don't have the contract written.
Oh, so they're trying to get over on the other person.
It could be.
Interesting. What do you think?
I think it just depends on the person and what they're thinking will happen.
Why do so many people gamble and not have a contract?
Well, they don't think anything's going to happen to them. They don't think that something will turn out bad.
Fair enough. Going inside the courtroom.
Yeah. I do know this, though. That's a mess. And that's going to have to be redone. And I know from you that costs $513. So why isn't he right that if that has to be redone, why should it be at their expense? And your answer is, because I called him. But, you know, nowhere in this letter, they're blaming you completely. Right. And this letter was written right afterwards when they said, we decided not to pay you, and here's why. You don't even respond to that and say, what, are you kidding me? That was your fault. Do you have any evidence that you told them, whatever you do, don't put in a pool till I tell you the coast is clear? I mean, how many weeks were they supposed to wait?
Until the sand was dry.
Which was when?
I wouldn't know.
Exactly. So, you know, like this is kind of, you know, if there's something as critical as don't put up your pool and it's summer, I would kind of expect you to be able to prove that you told that to them. They're denying that was ever said to them. You're saying, I left a message. Hey, can you prove you left a message? Show me your phone records. Something. Give me something to go on. Because what they're saying is your guys just botched it. They're saying that you actually explained how your guys botched it, that they put too much sand in one part because they came up to roots in another. They're saying you actually said that to him.
No.
Based on those pictures, I rule in favor of the defendant.
Thank you.
And so what was your reaction, the plaintiff here, when the judge just ruled against you?
Well, I thought she was wrong about it. I should have been entitled to something.
What have you learned? What mistakes did you make?
Always have a contract.
Oh, of course. Even
if it's for $100, always have a contract.
Of course, you're the businessman. Will you ever work without a contract again after you leave this courtroom?
Probably will, probably.
Don't.
I know.
Okay, all right, head right down this way. All right, so step on in here. What's your feeling on this outcome here?
I'm very happy that it was ruled in our favor. It was poor work, and I'm glad that the judge saw that for what it was.
You're fortunate to come out ahead because you made the same mistake he made. You allowed this work to take place, and there's nothing in writing.
There was nothing in writing, but still the expectation was that the job would be done correctly and all would have been fine.
The specs on the job should have been, and next time will be in writing?
Absolutely.
Even when you're the customer?
Sure.
Harvey?
Well, one reason why the defendant lost this case is he's the businessman, and he's the one who has the higher duty of responsibility. That will do it for this case. Litigants for the next case on the way into the courtroom right now.
This episode is brought to you by Nespresso and Samra Origins by the Weekend Coffee Collection.
Introducing Samra Origins. My collaboration with Nespresso is a connection to my roots, to my mother, Samra. Coffee that hits the right notes. It transports you. Crafted with unique notes and bold, soaring flavors. Experience a taste that moves you. Nespresso and Samra Origins.
Discover more at Nespresso.com.
This is the plaintiff, Ruth Bolden. She says she moved into an apartment the defendants were renting, and things quickly went from bad to worse. The place was in deplorable condition. She fell through the rotted staircase. Her neighbor was nasty, and she cut ties and moved out. Now the defendants refuse to return her security in full, and she's suing them here and now for the $2,853.08 they owe her. These are the defendants, Donna and Stephen Howell. Donna says the plaintiff was a nuisance tenant from the day she moved in. They had constant noise complaints from the neighbors. Her cat scratched up the window screens, and she couldn't pay the rent on time. Bottom line, the woman is lucky they refunded any of her security. But now that she's suing them here today, it's war. They're accused of letting a lady down. The defendants have filed a countersuit for $2,584.89 for damages, unpaid rent, and security returned.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case in the docket. The plaintiff says the apartment she rented from the defendant was so gnarly she fell through the staircase. Can't get her security back. But the defendant says the plaintiff is a big fat nuisance with a horrible cat. It's the case of Stairway to Hell.
You're welcome.
Okay, Ruth Bolden? Yes. You are suing Donna Howe and Stephen Howe for $2,853.08, double the security deposit, because according to you, they have wrongfully withheld it and exceeded the statutory time limit to return it. You have a counterclaim against her for $2,584.89 for rent. You want your security deposit you did pay her back to you because you've had a change of heart, and additional damages that you say she did to the apartment. Let's start with you. Tell me what's going on. You lived there for how long?
11 months.
Okay. And how did those 11 months go?
They were deplorable right from the beginning. The first weekend that I was there, I started to receive complaints from Donna stating that the tenant downstairs said there was too much noise in the apartment.
Okay.
At the time, I had not had all of my furniture in there. The only thing I had in the apartment that would cause an audible nuisance was a television.
Okay.
So I turned the television down. There were still complaints. I would turn the television off. There were still complaints. Complaints were constant.
From the tenant downstairs?
From the tenant downstairs.
Okay.
Finally, the evening of my baby shower, which was October the 13th, we had all come into the home. Everyone's tired. I'm beyond pregnant. I'm just totally tired, ready for the day to be over. I was in the house no more than 7 minutes. My phone goes off. It's a text from Donna. Control the volume of the noise in your apartment.
I know you lived there 11 months, and there's a lot of problems, and there's a lot of hostility. Then you move out. You decide you're moving out.
Correct.
You're moving out a month early.
That's correct.
And you're moving out a month early, I take it because of all the problems and you found a better place or whatever.
That's correct.
All right, now when you break your lease, according to you have their permission to break it?
That is correct. I have that on text message.
Okay, let me see the text message.
Sure.
Because one of the things they're suing for is rent for July.
Correct.
Now, I kind of want to go to you folks at this point. Did you agree with her that she could move out a month early?
She called us. I spoke to her on the 12th. She texted me and said, I need to speak with you, RE the lease. So I called her. At that point, she said, I do not have the money to pay you for July. And I said to her, well, I don't know, please be aware that there's late fees. So think about what you need to do, and, you do owe July's rent. She texted me back later on that evening, about an hour later, and said, I would be willing to move out early if that would work for you guys. I explained to her, Steve and I need to talk about that overnight. We, at that point, had a discussion and said, let's let her go. It's been a nightmare.
Okay. So you send her a text saying, we have no problem with you breaking the lease and moving out at the end of June. This way there's no confusion with anything being late for rent. I guess you meant rent.
Rent, yeah.
Okay. So now you're moving out, and you move out on June 30th. There's no question about the move out.
No question.
Right.
She moved out June 30th.
Okay. The question is, when do you notify them about your forwarding address?
July 7th.
Is that accurate?
That sounds about right.
All right, so then time passes, and you finally get a written list from them of the damages they are claiming. And let's talk about the timing of that, but first I want to kind of hear about the damages. What was the problem?
The place was filthy. We walked in there the day after, and throughout this whole thing, I had been in and out of the apartment. I had talked to her multiple times about the cat. We had just put in brand new windows in December. Talked to her multiple times about the cat scratching at the window screens. There was cat fur everywhere. She had a black cat that she allowed to climb on the countertops, on the windowsills, everywhere. She asked if she could paint the smaller bedroom for the baby. We said, okay, paint it, but paint it nice, one color, keep it simple. In addition to, she went farther than what we allowed her to do. We told her she could
Do
do
you
one
have a
color.
lease with her?
Yes.
Does the lease say that any permission to paint has to be in writing?
Yes.
And did you require the permission in writing, or did you verbally tell her, go ahead and paint
We
it?
had a verbal agreement, okay,
These
for
things are
one
in place.
color.
The reason why lawyers write them in there is to protect you.
I
Then you throw them
understand
out
that.
the window.
However, in the lease, it does say before she moves out, and we did go through, we sat there that day.
She needs to bring it back to
She
the
needs to
condition
bring it
was
back
in.
to where it was.
But she didn't repaint anything.
She
and
didn't
she
repaint
painted more than
anything.
the baby's room.
She painted the baby's room, but she painted it 2 different colors. It was on the bottom, it was a light green, and on the top it was a blue.
Simple to you is not simple to someone else. That's very vague.
Well, she used chalkboard paint.
Do you have pictures?
I have a lot of pictures. They set them up
Show
on
me
the
the pictures.
on the laptop. Do you want the hard copies or on the laptop? I don't know how to.
I think I want both, but I want to see them here
Okay.
first of all on the big screen because
All right. Well, let's see.
I can see them better.
All right,
Okay,
that's,
so that's
the baby's room with the chalkboard paint. She broke she was there by herself with a newborn baby. She broke every mini blind in that house. That's one there, the right-hand side, okay, where it's broken there. Every single one of them. This was her bedroom rug.
Okay.
And this is the Stanley steamer or Sears steamer cleaning it. Half of it was coming clean, and you could just see the difference in there. This is 11 months.
Okay.
11 months. All that black on there is cat fur.
Okay.
Okay. He actually had to do the rugs
you ever
twice.
vacuum?
Of course, Your Honor. I don't think she owned a vacuum.
Okay, go on.
This is the window in the kitchen with where the cat was scratching at the window. These windows were put in December.
Okay.
This was the stove. This was the front of the stove. These are, I don't know if you can see them from there, holes in the screen from the cat. Okay. That's the radiator in the kitchen. That's when she painted the bedroom, she somehow managed to get the blue paint all over the kitchen cabinet. Okay. That's the scratches from in the living room from the cat on the doorway. That's the bathroom.
Bathroom floor.
The bathroom floor. That's the bathroom tub with the pictures of the grout. The grout was just disgusting. This is the refrigerator door. We don't know what she did to the refrigerator door, if she scrubbed it with something or just never cleaned it, but the whole front of the stainless steel was completely scratched up
I
and
thought
then
that was
it
the
rusted.
idea behind stainless steel. It didn't stain.
Apparently it did.
I got it. I got the picture here. Hand me the hard copy of the photos.
Okay, hold that.
Yep.
And one of your concerns, however, and the reason why you're suing for double is because according to you, they missed the deadline on notifying you. So talk to me about that.
That is correct. On July the 19th, I sent
know if
Donna
I
a
have it
text
before.
asking her, because at this point she had stopped answering her phone. I sent her a text to ask
July
her.
the 19th, you moved out?
June the 30th.
June 30th. Okay.
July the 19th, I asked her when I should expect my security deposit. She responded in the text saying that we're wrapping things up. We will have this to you by the end of the month. That would have been fine because that would have been within the 30-day period of her needing to get it back to me. She did not do that. I actually have photographs of the postmarked envelope where she sent the information out on August 1. I received it on August 2. That's outside of the 30-day
That's
period that she
incorrect.
has.
Okay.
And I have that.
Show me what you've got.
This is a receipt that I mailed it on July 31st, and this is a receipt from the post office saying that she picked it up on August 1st at, I think it's 12 o'clock.
You have 30 days after the tenancy's over, and the tenancy was over.
30 days. The lease says 30 days after she leaves the property. And
I don't care what your lease says. I care what the law says. Okay. Let's get to you and these pictures, which have to be embarrassing. I mean, I don't know, kind of.
They could be if they were accurate. I'd like
What
to
do you think? They went around damaging all of their...
I'm almost sure of it.
Really? Do you have pictures of how you left the place?
Yes, ma'am.
Which does more damage, dogs or cats?
Cats.
Oh, you told me a minute ago, dogs.
That's right.
Why?
Yeah, it is. It is the urine.
Cat urine.
Yeah.
Cat urine. What do you think?
Dogs, because they shed and they mark their territory, and
Who's going to be the tiebreaker?
I would say dogs, just because they're crazy. They're always jumping all over the place.
Cats just sit there and pee. Got it. Go inside the courtroom.
There is video on the cellular phone.
On this? Okay.
Yes.
Okay, but this is a good idea to document it, but you're documenting exactly what her pictures show, which is that it's kind of dirty and that the blinds are broken and you're going really, really fast. So, and of course, you're going like this and they're zooming in on all the paint splatter, which you're going too fast to catch. I mean, you know, It is what it is. Let's see what you are claiming. According to you, your counterclaim is that, so you're suing for the rest of your security deposit plus the penalty of double the security deposit for failure to do it in a timely fashion.
Correct.
All right, you're suing for the rent, but I'm not going to find in your favor in that. I can tell you that right now because of the text that I see where you agreed to let her move out early. Okay, you want the money that you gave her for the security deposit returned because you're angry that she sued you. Okay. You want the money for the refrigerator door that you had never pinned on her at the time that you're writing a partial payment back, and you didn't list ever, not in any written form.
You're right. There was,
and you want the kitchen cabinets, $223.34 for what?
The paint.
Did you pay a housekeeper $200 to clean?
Yes.
Do you have the receipt for that?
Yes.
Okay. So you're not going to quibble with me on this, are you? That there are items you did not deduct for that you now wish to deduct for?
Yes, we ran out of time. Within the 30 days, we ran out of time to get everything done. We just couldn't get it done.
Oh, it's 30 days. You don't have to get it fixed. You have to claim it. And now that doesn't mean that, woo, case over, and you get to take double the security deposit home with you today. Because you still have a right to deduct, or to have me deduct from your recovery actual damages, whether they put it in the letter or not. What happens is mathematically, I start from the double figure and then start deducting what I find to be appropriate. So let me tell you guys what I find to be appropriate after reviewing all of the pictures and all of the receipts. I find the $200 for the professional cleaning and sanitizing of the unit to be appropriate. I find the $222.47 for deep cleaning the carpet of the pet fur and dander to be appropriate. I find what you're asking for painting the bedroom back into the condition that it was supposed to be appropriate. I find that what you're asking for the blinds to be appropriate. Okay, and that's the amount that you had originally deducted. Those are the things that you had originally deducted. So now let's talk about the things that you're asking for here today. Okay. I find the rent for reasons we've already discussed. You let her out of the lease, and I'm not going to pretend that didn't happen. The security deposit returned, well, I'm doing the math now, so that doesn't work. The refrigerator door is a bit of a problem for me because I just don't understand how that refrigerator door oxidates. So I don't have the proof of that, so I'm not going to allow that to be deducted. Yep. The kitchen cabinets, to get the paint off of it, I'm going to allow that, and the window screens, I'm going to allow that. What was the amount of the security deposit that you had on file?
$2,000.
$2,000, everybody agrees?
Correct.
Okay. And what was the amount that you've already returned to her?
$613.46, I believe it was.
That is correct?
Yes.
Yeah, okay. So here's what I did. I doubled the security as the law requires me to because you failed to meet the deadline. Then I deducted everything I think is appropriate, which I've gone over that some things are, some things aren't. Then I've also deducted what you already paid her. And that results in a net judgment in favor of the plaintiff in this case in the amount of $1,601.49. That's my judgment. Let me just say something because it's kind of bothering me. You are not the people that this statute's intended to punish. The statute was created because there are landlords out there who never get back to the tenant and just keep the money and figure that they'll exhaust the tenant. So to stop that from happening, they have to have a bright line rule and cut it on a certain day. You have to be on time or that's the penalty for you, okay? All right, good luck, folks.
Thanks, Your Honor.
You're welcome.
Let's talk to the defendants coming out here into the hallway after this case. What have you learned from this?
Screen our tenants a little more carefully.
You learned some more about the law.
Yep, learn to make sure that deposit's back to her on time and try to get contractors out there a little bit quicker.
How about itemizing that letter and getting it
we did.
to her before 30 days?
She got the letter in 31 days.
Under 30 would be...
I understand that.
According to the law.
I understand
So
that.
how long will it take you next time you're in this position?
Under 30 days.
Yeah, okay. All right, right around the corner this way. All right, come on out here. So the judge tells you that you're still responsible for damages nonetheless.
Yes.
What's your reaction to this outcome?
Well, I'd just like to say I thank the judge for her judgment. She was fair, and I probably should have cleaned up a little better.
Was it embarrassing to you to see those photographs in court of the place in such bad condition?
Not at all, because, like I said, I have photographs showing the opposite, so.
All right, over to Harvey then.
If you're a landlord or tenant, take pictures when the tenant moves in, take pictures when the tenant moves out.